It's my privilege to introduce our moderator, Dean Risa Goluboff, and our two panelists, Professor Akhil Amar and Professor Eric Schnapper, for our Panel 1's discussion about the 39th Congress and how it framed the 14th Amendment, the Equal Protection Clause, and affirmative action statutes to assist newly freed African Americans. Dean.
It is a pleasure to be here with these esteemed panelists and on this fabulous day. What you've planned here over the next 2 days is really stupendous. Just amazing people talking about this incredibly important topic. So I'm really thrilled to be here and to be a part of this. Our role this morning, I know Dean Chemerinsky started talking about the future already today, but our role is to, in my view, as a historian, start at the beginning and to talk about the origins of the legal interpretations, the origins of the political wrangling, the origins of the social movement claims about the 14th Amendment and the Equal Protection Clause that will be the basis, I think, for a lot of the conversation that comes out over the course of the rest of the symposium. So we have two wonderful panelists who are going to take us both deep and wide into that history, discussing the Equal Protection Clause, but in the context of the 14th Amendment as a whole, its legislative history, its other provisions, and the legislative actions taken by the Reconstruction Congress in around the same time that shed light on its meaning. So we're going to have a moderated discussion, and we'll follow that by Q&A. And as Alan had said before, you can put your questions into the Q&A function, and we will take them up later on. So my first question for both of you, and I think I'll start with Akhil, is, our panel is framing the discussions to come. And so we're going to start, I think, broadly, and then we can hone in. So can you talk a little bit about how the 14th Amendment fits into the Reconstruction Amendments more generally? What was the constitutional context in this post-war moment for the Equal Protection Clause?
Thanks, Risa. Such an honor to be with you and with Eric. Thanks to UNC, to Alan, to Dean Boger. We all just witnessed an extraordinary keynote, an introductory keynote by Irwin. That was an extraordinary tour de force. It was great to see my friend Ted Shaw. Can't wait. Speaking of Eric's, to hear the other Eric as well at lunchtime. I hear Garrick Foner, so it is a little intimidating to be asked to talk about the Reconstruction Amendments in history when Garrick Foner is waiting in the wings. Of course, there are three Reconstruction Amendments. They're the first set of amendments after the founding era, the first in 60 years, really. What you need to understand is how transformative the 13th Amendment was, because we start with a pro-slavery constitution that gives slave states extra seats in the House of Representatives and the Electoral College because of 3/5. Almost all the early presidents are basically slaveholders, Southern slaveholders or Northern men of Southern sympathies who play footsie with the South, because it's a pro-slavery constitution, unfortunately. So the 13th Amendment is utterly transformative, providing for uncompensated, universal, immediate emancipation everywhere, of a sort that had never happened anywhere in America that had, a lot of slavery. It's Russian Revolution style redistribution. It's just stunning. It could never have happened without a civil war. And so you might say, and Lincoln, when he was elected, was hoping he could do something like that over the course of 100 years. And now it's happened. So you might say, well, then why not? Why don't they just say mission accomplished? Let's have a beer. Wow. And the 14th Amendment and then the 15th Amendment will follow. Let me just make one point, and then I want to, obviously get Eric involved. Here's partly why they can't stop with the 13th Amendment. That's their initial inclination, because they, being Congress people, are politicians, and every time you solve a problem, this is advice for the students in the world. When you grow up, you solve one problem, you often create other problems. That's what success means, creating new problems for yourself. When they end slavery, they have this moment. I know that this is being recorded, but I'll say it's the oh shit moment. And it comes to people at slightly different nanoseconds, but they realize, oh shit, Okay, we thought we solved the problem, but we've gotten rid of slavery. 3/5 has become 5/5 because there's no slavery anymore. Blacks who are now freed in the South, okay, they're freed, but that means they're not voting, but it means they're actually going to be counting for more than they did before. The former Confederacy says, okay, we want back into the House and the Senate, the Electoral College, and they're going to come in with even more clout than before. Oh my God, oh shit, we're gonna need at least a Second Amendment, which we call the 14th, and it's gonna create issues in turn that will require a 15th Amendment about voting rights.
Thank you, Akhil. Eric, you want to add more about the kind of general constitutional circumstances that we're talking about?
Certainly, and again, let me express my thanks to UNC and our host for this wonderful program. I'm not usually in a program where I'm the other Eric, but I'm definitely only the other Eric here. The part of the history that I'd like to focus on is the race-conscious legislation that was being adopted between 1865 and 1868 by the same Congress, particularly in the early years, that adopted the 14th Amendment. For those of you who are an originalist bent, and I guess everyone's a bit selective about that. In this particular instance, it weighs pretty heavily in favor of a view of the 14th Amendment that's not entirely colorblind, although the situation's somewhat nuanced. And the debates about these pieces of legislation is eerily like the debates that we've had in this country since the 1960s about whether the government should be race blind or not, and if not, when not. So perhaps I could just walk through some of those pieces of legislation, and then if you want later on, we can talk about the debates. So the first of these was the Freedmen's Bureau Act of 1865. This and the next act actually happened before the 13th Amendment is effective. They're dealing with the consequences of the Emancipation Proclamation. So the 1865 Act protected freedmen and refugees. As a practical matter, the refugees were generally white. They were a relatively small part of the white population in the South. And so the provisions, insofar as they applied to both freedmen and refugees, and not all did, were virtually all the African Americans in the South, and only a handful of the whites there. It was selective, racially selective among the whites. And the original provisions of the 1865 Act dealt with a variety of things: food and clothing, the lease and control of certain lands that particularly had been conveyed by General Sherman in Georgia, and then a plenary control of all matters related to freedmen and refugees. The way the act was implemented was even more race conscious. And that's important for two reasons. First, the Freedmen's Bureau expressly reported to Congress what it was doing. It made this very clear. And then the debates about renewing the Freedmen's Bureau, that was a point of objection on the part of the opponents of the legislation, who pointed out that although the Freedmen's Bureau dealt with freedmen and refugees, in most respects, it was expressly only for freedmen. So the regulations of the Bureau with regard to a number of topics and the programs were limited to freedmen. And those included things that were probably most important: education, regulation of labor, land, overseeing the legal rights of freedmen, and registration of marriages, which was a problem among the former slaves. That stuff was exclusively operated for the freedmen, and the regulations said so. The Bureau provided medical assistance, and the numbers were that 96% of the people getting medical assistance were freedmen. With regard to food, 25% of the people getting food were refugees. And then there were some programs providing transportation, getting people back to where they'd come from or where they wanted to go. And that was evenly divided between the freedmen and the refugees. So that bill was in effect for a year, and Congress had to renew it, which it did in 1866. For those of you who aren't steeped in this history, the renewal of the Freedmen's Bureau was critical to the extent to which Congress turned against President Johnson. President Johnson vetoed the first Freedmen's Bureau bill. That produced a huge backlash. Congress moved more in a progressive direction, Republican direction back then. And actually the Freedmen's Bureau bill that ultimately passed was more race conscious than the one that Johnson had vetoed. So let me just skip ahead to what was in the bill that ultimately passed. First of all, the education provisions were expressly limited to freedmen because of the way they were set up. On the face of the statute, you could see that. Secondly, the provision about protecting lands was expressly limited to freedmen. It applied only to General Sherman's order of early 1865, and that order was only for Negroes in the terms of the order itself. And then the general grant of jurisdiction to the Bureau was over freedmen and refugees, but with a cutoff. And one cutoff was until they were self-supporting, and the second one was until they'd achieved the freedom provided by the Emancipation Proclamation. So the second clause could last past self-supporting, but it only applied to African Americans. So the Freedmen's Bureau lasted actually till about 1870. In 1868, Congress amended the statute and shut down everything but education. And education was exclusively for freedmen. The second telling piece of legislation was in 1867, and it concerned bonuses and bounties that had been provided to Union soldiers. Congress during the course of the war had created a number of those. I keep people in the military in the dark days. And the soldiers then had claims for reimbursement, and a lot of them were being cheated out of that money by unscrupulous agents. But Congress adopted first a race-neutral provision to help the former Union soldiers, and then there was in 1867 a provision that applied only to Black former soldiers. And it did so without regard to whether they'd been freedmen originally or they had been free African Americans even before the Civil War. That produced pushback again, like the other race-conscious measures. And one of the things that the opponents pointed out was that the new statute wasn't limited to freedmen and wasn't limited to uneducated African Americans. It covered all of them. And that was administered by the Freedmen's Bureau. The other thing that's interesting is there were a pair of social welfare provisions that were adopted in 1867. So one was about poverty in the District of Columbia. It was limited to freedmen and destitute African Americans. The second one was about famine in the South. In 1867, there was a crop failure, and large numbers of people were at risk of starving to death. That provision was not race conscious. It applied to everybody, although it was administered by the Freedmen's Bureau. And there was some pushback by the supporters, the original Freedmen's Bureau, that it shouldn't be in the business of helping everybody. It was there to help freedmen, but that's not what Congress chose to do. When it came to people who were starving to death, it chose very deliberately not to draw the distinctions that had been drawn with regard to the Freedmen's Bureau. And that was consistent with the way the Freedmen's Bureau had operated with regard to food and medicine. It hadn't drawn distinctions which were as rigid as they were about education. And the provision in 1867 applied to non-loyal Southerners. A destitute former Confederate soldier could get food. So it was broadly race conscious in the way that even the 1865 Act on its face was not. So that was the pattern of legislation. As I said, the debates were very much about race, but I'm going to come back to that a little later, whatever you want.
Great, thank you. So, when you put together Akhil's description of the three Reconstruction Amendments and your description of the various statutes that were passed around the same time, you get a sense of an enormous federal outpouring of protection for the formerly enslaved laborers and for Black Americans as a group, in both the constitutional and the statutory realm. So let's get a little more specific now. Akhil, I'm going to come back to you first, and then Eric, I'll come to you. So when you read the 14th Amendment, you read it within the context of a tremendous shift in federal power toward the protection of the freed people. But even beyond that, so, a lot of what we're going to talk about is the Equal Protection Clause, but I know you've written also about the first sentence of the 14th Amendment. So let's start there. What does it say? How do you read it? And how big is it? And how big should it be as we're thinking today about the Equal Protection Clause, but thinking about the whole amendment in this context?
It's enormous. So let's begin at the beginning, and I'm going to begin to, as I said, before there's the 13th Amendment. Of course, that sets everything up. And I said it's because 3/5 has become 5/5. We're going to need to talk ultimately about voting power, and that's going to be Section 2 of the 14th Amendment. It's going to be the 15th Amendment. But let's start at the beginning of the 14th Amendment, and I am going to be very personal here. This is my beginning as well as a human being. I begin, and I'm born, and I actually happen not to be Black or white, but I'm born in the United States. And because I'm born in the United States and my parents are not American citizens when I'm born, the Constitution, the 14th Amendment, gives me personally this amazing birthday gift. It makes me a citizen, an equal citizen, with full and equal civil rights as a citizen against the federal government and the state, all by dint of this one opening sentence. So it's my beginning. It's how when I look back on my life, I think that's why I want to be a law professor, because the very first day I'm born, a constitutional law professor, the Constitution gives me this amazing gift of full and equal citizenship. And that's the first sentence of the 14th Amendment. And wow, it's big. I'm going to identify 8 or 9 things that's all about. Even if we had nothing else, we could get it all or almost all from the first sentence. And since Eric very helpfully talked about the Freedmen's Bureau bill, I want to remind our audience of one other companion piece of legislation, which is the Civil Rights Act of 1866. And its opening sentences are actually almost identical to, and they were companion bills put forth by Trumbull. Eric is absolutely right. They were vetoed, and the veto overrides Johnson's veto. Andrew Johnson's vetoes were overridden. These were the first major veto overrides of an important bill in all of American history. Presidents had not had their vetoes ever overridden on important issues, but the Civil Rights Act of 66 and the Freedmen's Bureau Act are the two early on. And if you can get 2/3 to overrule Johnson, maybe you can get 2/3 for constitutional amendments. And the first sentence of the Civil Rights Act of 1866 is birthright citizenship. It's almost word for word the first sentence of the 14th Amendment. And so let me just read it to you, because I'm saying it is epic, and we forget about it when we talk about equal protection and due process and privileges and immunities and voting rights. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I'm going to identify, just stop me if I go too long, but like 10 quick bullet points about what this does. First, it means it has no state action requirement. You see, like the next sentence is no state shall. It's like the 13th Amendment in that regard. So 1, it's about my relationship to the federal government, and it's going to be a basis for, in effect, reversing corporation, equality rights, even against the federal government, because it says I'm a citizen, therefore an equal citizen, and the federal government has to respect that. That's Bowling versus Sharp, even before we get to equal protection. 2, because it has no state action requirement, Congress under Section 5 is going to be able to implement what it means to be a citizen. And I think what it means to be a citizen, and early Congresses did, not just against the state government, but I have a right to show up in a hotel or a motel, a train, a place of public amusement. I'm an American citizen, and Congress can pass laws saying cash out what that means, even when a state hasn't acted, but when we're in the public domain. But maybe not the private domain. Dinner parties are not the domain of citizenship. So if I'm excluded from a dinner party because people don't like my race, that's beyond the 14th Amendment. But now it's telling us, oh, it's about civil rights, not political yet, and not social rights like dinner parties. Why not political rights? Because being a citizen doesn't mean you vote. A child is a citizen. I'm born a citizen on the day I'm born, but I don't get to vote until I'm 18 or 21 or what have you. Women are citizens, they're equal citizens, but they don't yet have a right to vote. We're going to need a 19th Amendment for that. So this first sentence, the idea of people being born citizens is beginning to gesture toward a tripartite distinction between civil rights, like the Civil Rights Act of 1866, versus social rights, dinner parties, private action, and political rights, voting. Again, it applies to the federal government. It's about our relationship, citizen one to another. It's what does it mean to be born a citizen? I think it means to be born a free and equal citizen. It's a birthright equality idea. It's a constitutionalization of the Declaration of Independence idea that we're all created equal, we're all born equal in some fundamental sense, not just black and white. You're born black, you're born white, you're born equal. Oh, but you're born equal. I would say male and female. People are born male and female, but that's an equality idea. You're born Jew or Gentile, but you're treated equal. You're born the child of legal immigrants or illegal immigrants or slaves or free folk or white people. Doesn't matter. You're all born equal. You're born first in your family or fifth in your family. You're born equal, no primogeniture and entail. You're born in wedlock or out of wedlock. You're born equal. You're born gay or straight. Erwin mentioned Obergefell. You're born equal. Wow. That's a really powerful idea, this birth equality idea, and it begins to gesture toward what we're later going to call strict scrutiny for certain laws that treat people differently and unfairly because they're born differently. We shouldn't have that in America, but all sorts of other laws, like the difference between someone who makes $200,000 and someone who makes $150,000. The tax code treats them differently. There are all sorts of distinctions in our law that are okay, because they're not birth-based. So this sentence is going to begin to gesture toward an idea of strict scrutiny for birth-based laws, not just race, which is at the core, but sex and sexual orientation. If we believe with Gaga that people are born this way, sex, sexual orientation, wedlock, firstborn versus fifthborn. Final point. It gestures toward an idea of the privileges and immunities of citizens. What it means to be a citizen is to be able to claim rights. In the Bible, in the New Testament, St. Paul says, I'm a Roman citizen, and therefore I'm entitled to certain things. So it's going to anticipate the privileges and immunities clause, it's going to anticipate equal protection clause, reverse incorporation, broad federal power to protect rights. Now, here's the one final unfortunate thing. Not going to be about the rights of aliens, quite. It's about the rights of American citizens. It's about the rights of children of aliens. I'm a child of aliens. My parents aren't citizens when I'm born. But wow, it's a really powerful idea. And I think because there's so many other powerful clauses in the 14th Amendment, equal protection, privileges and immunities, due process, we sometimes overlook what an amazing beginning that amendment has.
Thank you, Akhil. And as we go forward in time, I want to come back to all the different groups that you were referencing there as having a home in that first clause. So when we think about the 14th Amendment itself and think about its breadth, one piece of it is that first clause. But another, Eric, is the Equal Protection Clause itself and the background to the 14th Amendment, where you find in your work all of the race-conscious ideas about helping the freed folks who were formerly enslaved in the 14th Amendment itself. So can you tell us about that legislative history and how you see those themes in the amendment and not just in the statutes that surround it?
Sure. So I think the key tie-in is people and time. The leaders of Congress and members that were the outspoken supporters of these race-conscious measures were also amongst the outspoken supporters of the 1866 Civil Rights Act and the 14th Amendment. They're pending before Congress. It's the same Congress. At some moments, they're pending at the same time. So it's fair to infer that whatever the 14th Amendment meant, it wasn't intended to invalidate the Freedmen's Bureau that was being adopted, reenacted at the same time, to invalidate the very statutes that were before Congress at that time. One has to read them together. And here the debates really become helpful because they really raise a lot of the issues that we're still grappling with today. And there are two sides to that debate. One of them is the opposition, which, as you'll see, looks eerily like a lot of what's said today in public debates and by increasingly probably a majority of the Supreme Court. And the other side of it is the arguments that were made by the proponents of the Freedmen's Bureau, which were more nuanced. So let me start with the opposition, because this throws light on the question of whether the Equal Protection Clause requires the Constitution be colorblind. The arguments there look very much like much of the stuff that one would hear from the conservatives today. The most consistent objection was that the Freedmen's Bureau was what they called then class legislation. It was inconsistent with the principle that everybody should be treated alike by the government. And that's in not only the legislative debates, it's in President Johnson's veto message. And there are two of them because he vetoed the Freedmen's Bureau bill twice. The proponents talked about there being equally deserving whites, the widows and orphans of Union soldiers, for example, or the Southerners who fought with the Union Army. They weren't given they weren't eligible for most of the programs operated by the Freedmen's Bureau. And the opponents talked about the fact that there were people in equal need who were white, who were just as poor, or in theory, just as uneducated. There's also an argument which we don't hear as much in the racial context. We hear perhaps more about aliens, which had to do with taxes. The opponents object to the fact that white people were paying taxes for a program that was limited to freedmen. There was also an argument that this was a form of, and the phrase actually appears, special rights. And that was also used about the 1866 Civil Rights Act. And we don't hear that as much in the racial context, but it was used very much in opposition to gay rights legislation when that was being fought over more in the States than perhaps it is today. The arguments for this legislation were complicated. And again, to the extent that one cares about the intent of the original framers, they pour towards a complicated view of what Congress could and couldn't do or what the states could and couldn't do under the Equal Protection Clause. And arguably, going back to Akhil's point, what the equal protection component of the Fifth Amendment would now be. The most repeated argument was that the freedmen had been in the past the victims of terrible mistreatment. Their labor was stolen, they were beaten, they couldn't learn, they couldn't go to school. And Congress was trying to right the wrongs that had been done to those folks. There's also a fair amount of discussion of local hostility to the freedmen in the communities where they lived. There's a discussion in response to the argument that whites aren't given similar programs. There's an argument that whites have the political power to take care of themselves in a way that the freedmen do not. Again, in part, this goes back to the fact that the 15th Amendment hadn't yet been adopted. And when it was, one of the rationales was that it would enable the freedmen and African Americans in the South generally at that point to look out for their own interests when Reconstruction was over. But that wasn't there. This is 1866. It wasn't even on the table yet. And that the feeling was that you could still make some of this argument today that discrete and insular minorities have less political power and therefore can more appropriately be protected by the government. So those are the main arguments that were made there. They have, in addition to the nuanced ways that the bills were framed, complicated implications in terms of what the framers might have thought was and was not consistent with equal protection.
So before we move on, I want to talk about what happens to the 14th Amendment in the courts afterward. But before we do that, can you say a little bit about those complicated implications about what the Equal Protection Clause may or may not have encompassed?
Sure.
What the thought was at that moment before, holding in abeyance what happens later, how you think about that?
Yes. Again, at some point, this is like, anytime we start down the road of originalism, you're trying to figure out, well, what would the framers have thought if you told them everything that was going to come? I think the framers would have thought that addressing societal discrimination was totally appropriate. That's what this was about. Congress didn't say, we've been enslaving people, we've been stealing their labor, the federal government's been denying them education, we've got to make right what we did wrong. This was making right something that somebody else did wrong. If you go back to full love and the court just doesn't want to hear anything about correcting societal discrimination, that's what the framers thought they were doing. Secondly, they clearly, I don't want to use the word clearly about anything, but they were distinguishing between measures that had to do with self-support, both land and the enforcement of contracts and education. That was an area where they were doing the most that was race conscious, as opposed to on the other end of the spectrum, food, where they did not draw those distinctions. So if you were looking at affirmative action programs today, the framers would probably want you to draw this kind of distinctions. Now, interestingly, much of the current fight has been about things at the self-supporting end. Education, minority set-asides, those fall squarely in the heartland, what the framers would have thought was appropriate. Whereas if you were to propose giving more food stamps to African Americans or giving them preferential treatment in terms of Section 8 housing, I think they probably would have not been comfortable with that. So if you look to I try to think through the current rationales for race-conscious affirmative action, and some of them I think the framers would have been comfortable with, some of them which they wouldn't have been, some of which would have been totally new. So insofar as we were arguing for affirmative action to deal with societal discrimination, the thing that full law tells us we're not supposed to do, the framers would have been fine with that. Insofar as these measures were intended to defeat then ongoing discrimination, I think they'd have been fine with that. That comes up as well. And there's a story there that's a bit like Shelby County we can get back to. On the other hand, there's very little that looks like reparations in the debates. I saw one passage talking about what we owe the former slaves, but it's not the drift of what's going on here. And there are a couple of things that clearly aren't there. One of them is the notion that something should be done because discrimination and mistreatment against the ancestors of current citizens it has current effects. That idea is not there. It's really not there for historical reasons, because there were virtually everyone, all the blacks in the South, had been slaves until a couple of months earlier, or maybe a year or two earlier, as the Union forces marched south. So it was just a phenomenon that didn't exist. And finally, the rationale that is much discussed now about higher education, about the benefits to an enriched and effective education of having groups from different backgrounds, that's definitely not there. The schools that were operated, with very few exceptions, only had African American adults and children in them. There's some scattered instances where the white children of the white teachers were in those schools. But this is a wholly new idea, not something that would have been necessarily anathema to the framers. It's like telephones and the framers of the Fourth Amendment. It's just not part of the world they knew. There was not much higher education. But you can't find a basis for the value of diversity to a workforce or to a school. There's nothing like that in the thinking of the framers.
Mm-hmm. Great. So I want to come back to Shelby County later, but before we get to the present or the near present, let's stay in the 19th century a little bit longer. So what you've both described are incredibly expansive understandings of the 14th Amendment. And as we know, in the Supreme Court, in the years after, in the decades after the ratification of the 14th Amendment and the other Reconstruction Amendments and the passage of these laws, the Supreme Court really radically narrows the scope of the 14th Amendment. So can you talk a little bit, Akhil, about the civil rights cases of 1883 and Plessy in 1896, and how you see the amendment being interpreted there, and where you see the opportunities for the court to have read the amendment the way you do, and what the court does instead.
Thanks. So I want to go back once again to just how radical the 13th Amendment is in the first sentence of the 14th Amendment, and then even the congressional empowerment clauses. So our constitutional tradition, unlike, say, European ones, has a very strong focus on the government. We call it the state action doctrine. Our rights are almost always against government, state and federal. So state action here means not just state as opposed to federal government, but government as opposed to non-government. The 13th Amendment, though, has no state action requirement. It's actually about a broader phenomenon. Even if one private person enslaves another, that's a violation of the 13th Amendment, and Congress is supposed to do something about it. It's a requirement of affirmative government measures to ensure that neither slavery nor involuntary servitude shall exist. So both a mandate of government action and an application against private action. That's the 13th Amendment, and that's radical. And Eric mentioned earlier, he says, they're not just trying to remedy past governmental wrong, but a broader social wrong that they're trying to rectify called slavery. So the 13th Amendment is radical in that regard. Almost nothing else in the Constitution has that feature. So too, I argued about the first sentence of the 14th Amendment. It does not say no state shall. So it applies against the federal government, and in 10, it's about the relationships of citizens between themselves horizontally. It's a little more French that way. It's about fraternité and not just liberté and égalité against the government, but more, we are equal citizens, you and I. And if we were French, we'd call each other citoyen, or comrade, or something like that. It's about horizontal relations. When we meet at the mall, or in at Disneyland, or in public conveyances, a train, a steamship, a place of public amusement, a place that today the shopping mall or something like that. Why do I mention that now? That's going to take me forward to the civil rights cases of 1883, because in tandem with that first sentence of the 14th Amendment that has no state action requirement, and the 13th Amendment that has no state action requirement, there are congressional empowerment clauses, Section 2 of the 13th, Section 5 of the 14th, they're going to be followed by Section 2 of the 15th, that are sweeping. The Bill of Rights begins saying, Congress shall make no law. The framers of the Bill of Rights were concerned about too strong a federal government, and the rights are only against the federal government. And now we're having amendments that are restricting social practices and state laws, and ending with sentencing, Congress shall have power, Congress shall have power, Congress shall have power. Using the word appropriate, which is borrowed from McCulloch, which means sweeping power. Congress shall have broad power. Irwin mentioned Prigg versus Pennsylvania. The courts upheld broad power to protect the slaveocracy in Prigg. And now Congress wants to say, oh, we want to use that same broad federal power to protect the former slaves that Joseph Story and the Supreme Court in Prigg, which Irwin mentioned, the Supreme Court allowed Congress to pass sweeping laws to protect slave masters, Why can't they pass sweeping laws to protect the former slaves? And the 1875 Civil Rights Act, Eric and I have been talking about 1866 statutes, but now flash forward, is in effect an early version, in important parts of it, of what our audience would recognize as the 1964 Civil Rights Act. It prohibits race discrimination in trains and steamships and places of public amusement. Today, that would be Disneyland or something like that, hotels and the like, public houses, call them pubs today, places, common carriers and conveyances. And the Civil Rights Act of 1875 says no race discrimination in those places. Enter the Supreme Court in 1883. This is Irwin's story. They strike down what Congress has done. And one person, and here's what they say. You are the state action doctrine. The Constitution only guarantees rights against the state, and Congress here is regulating private entities like hotel owners, Disneyland, places of public amusement, steamships, state action doctrine. Here's what Harlan says, alone in dissent, John Marshall Harlan. This is going to be the same Harlan who is alone in dissent in Plessy versus Ferguson. He says, first of all, the 13th Amendment has no state action requirement. And maybe it's true that race discrimination at a hotel isn't slavery or involuntary servitude, but it's a badge of slavery. It's an incident of slavery. It's a relic of slavery. It's part of the slave. It's part of the racial discrimination society that gave us Dred Scott and slavery. And Congress has power under Section 2 to go far beyond Section 1. Section 1 might not say badge, incident, relic, but Harlan says Congress has sweeping power under Section 2, which is going to become in the 1960s Jones versus Alfred Mayer, which is forgotten. Okay, and why? He says, because Congress had sweeping power to prohibit to protect private slave masters in Prigg versus Pennsylvania. Why shouldn't they have sweeping power to McCulloch-like power to address private wrongs? The 13th Amendment should be read generatively, and congressional power should be read broadly. That's one of Harlan's moves. But his second move is based on the first sentence of the 14th Amendment. He says, it doesn't say no state shall. It says citizenship. Yes, citizenship isn't about who gets invited to Risa's dinner party. She gets to invite whoever she wants to her dinner party because that's the private domain, or whoever she wants to have involved in her private life. But hotels are public houses. They're open to the public. Trains and steamships and places of public amusement. This is the domain of citizenship, or at least it can be if Congress so decides, and we, the court, should be deferential to Congress, the way the court was in McCulloch, the way the court was in Prigg versus Pennsylvania. So Harlan, standing alone, as we can oppose these laws. He loses, so that's why in the 1960s we have to refight that fight. Finally, one sentence on Plessy. See, because if Harlan was right in Plessy, and we all think he is today, then he was right in the civil rights cases of 1883, 13 years before, and that's not what the Supreme Court says today. The Supreme Court has revived all these bad doctrines of the civil rights cases. That is become City of Burney and Shelby County. It's all a narrow reading of Congress's enforcement power, and it goes all the way back to the civil rights case of 1883. Here's why Plessy is so analogous, because Harlan actually says in Plessy that race discrimination, he actually invokes the 13th Amendment. Why is he invoking the 13th Amendment? Because not being able to get on a train isn't slavery. He's invoking it because he thinks it's a badge of slavery, and that maybe this segregation isn't a violation in public places, like hotels and trains. It's not a violation of 13th Amendment Section 1, but Congress can make it a violation of law under 13th Amendment Section 2, and he thought Congress did do that. And the court was wrong in the civil rights cases. And so look, all the court had to do is enforce the Civil Rights Act of 1875, and plus it becomes an easy preemption case. The Congress in the Civil Rights Act of 1875 has said no racial inequality in railroads. All you'd have to do is just enforce the congressional law, basically say racial discrimination in railroads really isn't equal, as it's just a matter of simple preemption. But instead, last sentence, the court, and this is what Irwin is saying, strikes down a congressional law in which blacks, in a legislature for which blacks voted and in which blacks voted, strikes down that law, but upholds state laws in Louisiana, in Plessy, where black people aren't voting in the legislature and aren't voting for the legislature. And all they had to do, and this is what Irwin is saying, is enforce that Civil Rights Act of 1875, which they didn't. And Harlan says they should have because of not just the 13th Amendment, but the first sentence of the 14th Amendment, which radical has no state action.
Great. So there's a lot in there, and that was fabulous. Before I turn to Eric, and I might try to get some disagreement going. We'll see. I just want to remind the audience that you should put questions in the chat in the Q&A function. We're going to talk for, I think, another 15 minutes or so, but then I would love to take Q&A from the audience. So if you have a question, please put it in there. So Eric, I wonder if there's some disagreement between the two of you, because what I hear Akhil saying is that the state action requirement might limit the Equal Protection Clause and its operation, might limit the Due Process Clause and its operation. And so in order to get to the kind of fulsome and expansive interpretation of the Constitution that I think you both want to get to, he thinks you need to go to the 13th Amendment and the first sentence of the 14th Amendment. Whereas I think that your claim is slightly different from that. Your claim is no, even with the state action requirements, it is still the case that the conception of the 14th Amendment was broad enough that you don't necessarily have to go in the directions that Akhil does in order to say that affirmative action is justified or that the civil rights cases of 1883 were wrongly decided. Am I right to see a little daylight between you two there?
I'm not sure you've managed to pick a fight quite yet.
Okay. I'll keep trying. I'm also happy if we don't have a fight.
I'm contentious. You'll get there. It's not that hard to provoke me. But I think what I've been saying so far just has to do with a limitation that I see in the reach of the Equal Protection Clause. That is, I think it's a fair reading of the legislative history that it was not intended to be completely colorblind, although it was in some ways. It's complicated. And I don't think that addresses either of the questions raised by what Akhil said about the scope of prohibitions against discrimination when they do exist, or about state action. Looking at the debates that surrounded the Civil Rights Act, and if some familiar with debates about the 14th Amendment as well, about the 1866 Civil Rights Act, I think it's clear that Congress did not think the 13th Amendment required state action. The interesting thing is when you think about the civil rights cases and you look at the discussions about the Freedmen's Bureau, Congress thought it was acting under the 13th Amendment. That's where it thought its power came from. And the debates are not about the wrongs done by states. I was looking through all the posts I had in the article last night. There's not one about states. There's maybe one about laws. The description is about the way in which the slaves had been mistreated by the slave owners. That's the bulk of it. South Carolina wasn't stealing people's labor. The slave owner was doing it. So it's very much about things that private individuals did, obviously with the connivance of the state, but the focus isn't on the state, except with regard to education, where the state was prohibiting it. So I think it's fair to say that Congress thought it could do something about that. It could, under the 13th Amendment, correct the harms caused by private conduct. So I don't think Congress would have been surprised at that point of the notion that under the Section 2 of the 13th Amendment, it could adopt legislation dealing with private actors. I think the other takeaway from these debates is Congress didn't think slavery was just chattel slavery as a concept of property. Don't bother me about the details. It was about more than just you can own a human being. In fact, it wasn't really the debate they were having wasn't about that at all. If we think, as we were taught to in law school, of property as a bundle of rights, slavery to them was a bundle of wrongs. And they were cataloging those wrongs, cataloging them. And it goes back to the point that Akhil made about badges of slavery. Slavery was a bunch of badges, but that was the system. And it had all these consequences. You weren't allowed to learn. You couldn't leave the plantation. You could be beaten. You couldn't get paid for the work you did. Your children could be taken away from you. That sounds eerily familiar in our era. This was this bundle of wrongs. And so it would have made sense to them that there would be a bundle of wrongs by private parties that Congress could correct through measures like the Civil Rights Act. I mean, you're seeing that bundle of wrongs concept and what Congress thought under the 13th Amendment it could correct. If not educating someone wasn't a wrong under the 13th Amendment, they had no business fixing it. Congress didn't have plenary authority over the ills of America. Its authority was under the 13th Amendment. So unless the problems they were trying to correct were problems that implicated the 13th Amendment, the power wouldn't have been there. So I think the 13th Amendment looks like a very broad source of authority to deal with any manner of racial discrimination.
And if I could just jump in and make a bridge of connection. The 13th Amendment is on the books. Where does Congress get the power to pass the Civil Rights Act of 1866, which says no race discrimination by states, but even in northern states, even states that never had slavery under the Constitution, like Massachusetts. And Congress thinks it has power to do that under the 13th Amendment, read broadly in light of Prigg and McCulloch and that word appropriate. So Trumbull says we have very broad power to under the 13th Amendment to deal with sort of all of the racial apparatus that underlay the slavery system. Johnson says, no, you don't have enumerated power, and he vetoes the 1866 Civil Rights Bill partly on that ground. Congress overrides the veto. And that first sentence, remember, says everyone's a citizen. Everyone born in the United States is a citizen, which goes way beyond slavery, you see. Now, Johnson arguably has a bit of a point because, gee, that's a very broad reading of congressional power. Here's the final point. If you think that, here's the one thing, if you're a citizen, you should never do. You should never support a 14th Amendment whose first sentence echoes the first sentence of the 13th Amendment of the Civil Rights Act and says Congress shall have power, yet another provision, because the 14th Amendment is partly there to provide a secure constitutional foundation, not just because of Section 2 and 3/5 becoming 5/5, which I told you before, because without a 14th Amendment, the Civil Rights Act is vulnerable because can you overrule Dred Scott by merely a statute? Dred Scott says blacks can't be citizens. First sentence of the Civil Rights Act is, yes, they can. Can you do that by a mere statute? And especially when Johnson's saying you don't have power. Enter the 14th Amendment that echoes the Civil Rights Act word for word, that first sentence of both the statute and the 14th Amendment. It says Congress shall have power. And if you don't want broad congressional power, you shouldn't vote for the 14th Amendment because they just showed you with the Civil Rights Act how they interpreted the Congress shall have power under the 13th Amendment. So I think the 14th Amendment ratifies in an obvious big public way a sweeping congressional power because Congress passes an amendment that says we the Congress have power, acts under it. We see what they do, which is very sweeping, going way beyond narrowly slavery itself, chattel slavery. And if you don't like that, vote against the 14th Amendment. The people like it and they vote for the 14th Amendment. and then again for the 15th Amendment, which has another congressional empowerment clause, which Irwin invoked when he talked about Mobile versus Alabama. And all this is why Shelby County is a disgrace. And City of Bernie is completely wrong, because these were amendments written by Congress for Congress, with Congress implemented very broadly. And the American people, seeing all of that, said, yes, do it again, more, please.
So I want to, Eric had mentioned he has something to say about Shelby County too, and I want to come to that in a second. But let me just staying on the late 19th century court for a minute. You know, there are those who would defend the court. I'm not among them, but there are those who would defend the court and say, what the court was doing was really not about, reasserting racial subordination. It was really about the worries about the transition in the relationship of federalism and the role of the states and the role the states were supposed to be able to play. So how do you both respond to that argument about what the court thought it was doing, perhaps at the time?
In one sentence, I would simply say, and I do think Irwin's keynote was very powerful, so thank you, Irwin, for that. Boy, it's a double standard. And this is what Harlan says in dissent in the civil rights case. He said, wait a minute, you got the provision of the original Constitution. It says no state shall, and it doesn't say Congress shall have power to enforce. And it says no state shall, and yet in Prigg, the court upholds this congressional statute that regulates private people beyond no state shall, and in a massive pro-slavery way, and we, the court, uphold it. And now we have an amendment. It uses the same word appropriate. Congress wants to do for the former slaves what earlier Congresses had done for former slave masters with the court's blessing. And now you're saying we can't do it. You've moved the goalpost after the ball is in the air. You can't do that. So where was the federalism argument in Prigg? That's what Harlan says in dissent in the civil rights cases of 1883, and I'm with him.
Great. Eric?
Well, I have maybe a less expansive way of saying something of the same thing. In the debates that go on in 1866, one of the recurring arguments, it's really a background argument of the opponents, is that Congress, the national government, has no business mucking around with things that are happening among citizens or among individuals, private individuals in the states. Not just regulating them, helping them. It's not the business of the national government. This is a state and local problem. And the opponent's view is, acting under Section 2 of the 13th Amendment, the 13th Amendment has revolutionized the role of the federal government. It has given us a different responsibility, and it is very much given us responsibility for dealing with certain kinds of problems. We don't have plenary police power, but if we're dealing with the problems of the freed slaves, and I think Akhil makes a good point, it's somewhat broader than that. They see racial discrimination, at least beginning to see that, as inextricably intertwined with getting rid of slavery. We're in the business of dealing with that. And if we can deal with that by setting up schools or by setting up a court system for the freedmen or registering marriages, then they would undoubtedly thought we can deal with it by regulating the way African Americans are treated if they go into a hotel or a railroad. It was meant to be a revolution, at least insofar as it empowered Congress and the national government to deal with that problem. And it makes no sense to say, well, you could have federal railroads if you think you need it. You can have money, you can spend money to move people around, but you can't regulate the way that people are moved around if a railroad company does it. And I think they would have said, we're in the business of dealing with these problems. And although the 1866, Freedmen's Bureau Act was an affirmative social program, it doesn't make any sense to say there wouldn't be a comparable expansion of the regulatory authority of Congress. So I think, but again, that's under the 13th Amendment.
Okay, so Shelby County, Eric.
Well, there's a story that comes out in 1867 that just eerily like Shelby County. And I mean, this is after the 13th and the 14th Amendment have been written by Congress. The 14th Amendment isn't ratified yet, so I don't know how much you can read into the intent of the states in ratifying it. But the 1866 Freedmen's Bureau Act was set to expire in 1868. And in 1867, General Howard, who had been running the Bureau through the whole time, thought things had sort of worked out. And there were these schools throughout the South, operated, I think, mostly by Northerners, and they were functioning. And so he recommended that Congress shut down the Bureau, thought things were under control, and started to withdraw the Freedmen's Bureau involvement in the schools. What then happened, he reported to Congress, was that the white Southerners immediately started disestablishing those schools, shutting them down, driving out the teachers. And so he changed his mind and said, whoops, I was wrong. I thought racism and the mistreatment of slaves was over, and we could move beyond such things. As soon as we turn our back, things were good only because we were there. Once we started to leave, things went bad again, and we need to stay. And it was on that basis, on the basis of what he'd seen happen when they started to leave, that he recommended extending the Freedmen's Bureau, which is what Congress did. It's obviously like what happened with voting laws in the South after Shelby County, and not as fast, although it was very fast in Texas. But we've really seen a resurgence in discriminatory legislation and a flourishing of innovative ideas for disenfranchising people in the wake of Shelby County. It's very much like what General Howard saw in the South when they started to close down the Freedmen's Bureau.
Akhil, you look like you want to add something.
I wanted to bring in gender in 3 or 4 different ways, if I could. The Civil Rights Act of 1866 talks about how people are entitled to the same rights as whites, and it has a racial focus. First sentence of the Constitution doesn't use the word race. Would have, the 15th Amendment does, and I think it's about a broader birth equality idea. That's just why I said it means we're people, not just black and white, but male and female. I would say gay and straight if people are born gay and straight. So that's one. It's going to lead to an equality doctrine, I think appropriately, that's not just limited to race. I'm going to eventually talk about Justice Ginsburg, because we're talking about women, and I just can't not think about Justice Ginsburg and that dissent in Shelby County, and again tell you something really personal about it, but I'll come to that just at the end. That's another thing. Slavery is such a big and pervasive system. Eric, I think it'd be great if you wrote a book called Bundle of Fronds. That's an amazing concept. We think of property as a bundle of sticks. We think sometimes of a bundle of rice. It's brilliant. Slavery has so many different parts of it. It's such a big, complicated bundle. And Risa's work, for example, has talked about the labor side of the 13th Amendment and unions and other things. Here's a whole other side. Let's, for example, think about the gender side of it. Half of the slaves are females, and for them, slavery takes a very gendered form. They're wet nurses against their will. They're breeders against their will. They're sexual playthings against their will. So when you smash slavery, which is what the 13th Amendment promises, slavery is such a big, pervasive social thing. It ramifies in so many ways. You're dealing with gender, and basic things. 13th Amendment, the first sentence of the 14th Amendment, it has a gender angle too, for example. Yet another one. If we basically said, oh, you're only a citizen if your parents are citizens, think about the following. Oh, well, what if your mother is not a citizen, but she says, actually, oh, but my husband is? Your mother's husband actually your biological father? And if not, then you actually don't derive from citizens. Now we're going to have to investigate her, privacy and all the rest to decide whether you have a citizen. We don't do any of that. They're interesting gender angles on all of this, because the 14th Amendment doesn't say race. It's not just about race. Race is at its core, but it's about other things as well. And that brings me to just one final tribute to Justice Ginsburg, because I did think that was one of her greatest opinions. It was an epic dissent. And I apologize, I maybe am overly personalizing it, but here was a key moment for me. The key moment in her dissent is when she says, here's why the majority gets it wrong. They just don't get Reconstruction and how big a thing it was. She says, nowhere in today's opinion is there a clear recognition of the transformative effect the 15th of the Reconstruction Amendments aim to achieve. Notably, the founders' first successful amendment said that Congress could make no law over a certain domain. In contrast, the Civil War amendments used, quote, language that authorized transformative new federal statutes to uproot all vestiges of unfreedom and inequality and provided sweeping enforcement powers to enact appropriate legislation targeting state abuses. And that means a lot to me, because that's a quotation from my book, which he cites me, and I was very proud to be enlisted in this project and cited by a great civil rights crusader for women's rights and African-American rights and equality more generally. And the key is she understood the transformative nature of the Reconstruction Amendments. And it begins, as you properly began us, Risa, I think, with the 13th Amendment, which is just so unlike almost everything else in the Constitution, which is just sort of narrowly about the federal government shall not do this, the federal government shall not do this. This says no slavery anywhere, and the federal government must do things. It must enforce this. That's sweeping, and I think the first sentence of the 14th Amendment is comparably sweeping, especially when added to congressional power, no state action requirement, and no limit just to race.
Great. Thank you. So we have a question from Erica Wilson, which I think follows on this whole conversation about the 13th Amendment. And she asks, what are some specific examples of the way the 13th Amendment could be used to address modern issues of racial inequality that have roots in enslavement? For example, could Congress realistically use the 13th Amendment Section 2 enforcement power to define modern racially discriminatory policing practices such as stop and frisk, qualified immunity, et cetera, as badges and incidents of slavery, and enact legislation that disincentivizes such practices? Who wants to answer that?
I think they can. I think the biggest thing, though, about the 13th Amendment is just the reminder that Congress has the power to regulate private structures, because 14th Amendment and the 15th Amendment also come in when you're trying to regulate state police or all the rest. So the most radical thing that the 13th Amendment would add is the ability to regulate a private structure. And one case that has just fallen into a hole and has been forgotten, it was an epic decision by the Warren Court at its apex. The oral argument took place a day or two after Dr. King's assassination, is Jones versus Alfred Mayer, which read the 13th Amendment very, very sweepingly indeed to give Congress power to regulate certain private conduct. I was only 9 years old at the time. I think Eric was 10 or 11, so he may remember that better than I do. So I'm going to defer to him on that, because he may remember Jones, but I was just a kid when that came down.
Eric?
Well, I'm not going to get into how much I can remember from that particular year. But let me respond to the question, because I think it raises a number of different issues. So first of all, with regard to qualified immunity, that is a creature of Supreme Court interpretation of Section 1983. Congress could overturn that tomorrow and would be well advised to do so. But I don't think there's any constitutional question about the ability of Congress to deal with that. Secondly, with regard to stop and frisk, insofar as there's a claim that that stop and frisk was being administered in a racially discriminatory manner, that is, let's stop and frisk that person, he's black, and let's not stop that person, she's white, that's just a hardcore 14th Amendment violation. And Congress doesn't have to do anything about that. Sure, it could do more, but it's clearly unconstitutional. The broader question here about the police goes to an issue we haven't talked about, which is the original meaning of the Equal Protection Clause. which in one respect at least, I think really goes beyond invidious discrimination. The Equal Protection Clause, strangely enough, was actually about protection. It was actually about the problem. It was framed first in the debate about slavery and then in the debate about what happened afterwards. That a slave didn't enjoy the protection of the law from beating, from forcible, from kidnapping, and then in the wake of emancipation, the southern states were not protecting the legal rights of former slaves. They could be beaten, they could be attacked if they tried to leave the plantation, and there was a need for physical protection that wasn't there. The abolitionists referred to slavery as murder, kidnapping. It just to them looked like ordinary crimes being perpetrated every day, and the government wasn't doing anything about it. And remember, in a number of southern states, there wasn't an affirmative slave code. Slavery existed because these abuses simply weren't dealt with. So I think when you think about, maybe partially about stop and frisk, but partially about the extent to which physical abuse of minorities, particularly African Americans, by the police is a pervasive and intractable problem in this country. That is a hardcore concern. Lies very much at the core of the Equal Protection Clause. And I think the power of Congress to deal with the failure of the states to protect people from violence is at its apex under the 14th Amendment. That it lies, it just fits, it's why it's framed in this way that we say equal protection and we don't hear it. We hear equal, we don't hear protection. It's a 19th century way of saying don't discriminate. It's not, it was about protection. So I think there the power of Congress is particularly great. All you need is 5 more votes.
Right. So there's a phrase from this era that follows through into the 20th century and is actually a big part of the first Civil Rights Commission of the modern era, the Truman Civil Rights Commission, the idea of the safety and security of the person, right? That there is an affirmative obligation on the part of the government to secure. This was the title of that commission's report, to secure these rights, and that there was really an affirmative duty there. So we have a minute and a half left. Any closing comments from each of you?
Thank you very much. And it's been
I can ask one last question if you don't have anything closing to say.
Well, let me just say from a historical perspective, it's very interesting reading these things again from 150 years ago. It's striking how novel the problems are. How, the analogy, the story we already told about the Fourth Amendment and telephones, we're just living in a world that doesn't translate directly into the world that the framers of the 14th Amendment saw. And I think the real challenge for the courts and the national government is to take principles which are written about a different era and be faithful to the underlying purpose, but understanding that you can't go back and read the journals of the Congress of 150 years ago and find people talking about the things that are happening now that are about a world they just didn't know. Yeah. And that's not easy.
Yeah.
And here's one little piece on the other side. You've often, and it relates to Kamala Harris and back to my, the conditions of my birth. There are folks who say, well, maybe Amar's a citizen because his parents were, even though they were aliens and they weren't green card holders even, they were here legally. But of course, children of illegal aliens, they can't be citizenized, these anchor babies and all the rest. And like, what part of the amendment don't you understand? It says everyone born in the United States. And they say, well, they weren't thinking about illegal aliens because they didn't have such a concept because we have federal immigration laws. Oh, enter Jerry Newman. We're going to hear later from Michael Klarman. Jerry Newman is his great colleague at Harvard. He said, actually, there were technically illegal aliens in 1866 because Congress prohibited the international slave trade in 1808. And people were still being smuggled in illegal, not at their own behest, but they were sexual slaves and other kinds of slaves. And that's happening in New York City today. People are being smuggled in as sexual slaves and other slaves against their will. We had that in the 1860s. Abraham Lincoln refused to spare someone from the death penalty who was a slave trader. And Abraham Lincoln didn't like putting people to death. But there were actually people who were technically illegal aliens. They were slaves in America who had been smuggled in, and their children, Ray Newman says, and I'm with him, were at the core of those who were absolutely citizenized by the first sentence of the 14th Amendment. So Eric's work does show the world is different, but we can learn a lot from that Freedmen's Bureau Act of those Freedmen's Bureau Acts. And the world is different, but Jerry Newman has persuaded me, they're interesting parallels, even as they're obvious differences.
Wonderful. Well, with that, I want to thank you both for this fascinating conversation. Thank you to Ted Shaw and to Alan for having us and for putting on this incredible symposium. And enjoy the rest.